Hi guys, David Campanile here, owner of Campanile Law, located in the great state of New Jersey. We do estate planning and probate. If you'd like to talk to me about estate planning, and yes, talking to me initially is free, so take advantage of this. You can contact me at njestateattorney.com. So today I want to talk to you guys a little bit about something that crossed my desk about a week ago. It's about separation and estate planning. So this is a little different than divorce, so I thought it would be really important for people because sometimes, we do trial separations, we do separations instead of a divorce, so it kind of can alter the estate plan. So hear me, I'm going to go through what happens and then how we can fix it as quick as I can. So here's what we do. So I know we get separated, and in this case, the person was married for 12 years, passed away, had no will, but he was estranged from his wife for 12 years. She had nothing to do with him. The thing is, under the law, she's still the surviving spouse because there's only 3 ways to break a marriage. It's annulment, divorce, or death. The marriage was never dissolved while he was alive, so now his estranged spouse is still deemed the quote-unquote surviving spouse. Now, what does this mean? Well, to add a little bit more in, he had a child with this spouse, but had 2 children previously with another person. So this gets a little bit more tricky. But in this scenario, basically, the surviving spouse is due up to the first $150,000 in the estate. The estate was worth more than $150,000. So she gets the first $150,000, but because he had 2 children in a previous relationship and one with the surviving spouse, the rest of the balance gets split 50-50. 50% to the other 2 children from the previous relationship, and 50% goes back to the surviving spouse to care for their child. Now, this is kind of, I know it's a lot to wrap around, but in this instance, they were only separated. They weren't legally divorced. They did not have an annulment. Therefore, spouse gets money, even though she had no involvement for 12 years. I know it sounds kind of crappy, but this is what happens. So how do we fix this situation, and how do we prevent it? Well, in this case, the person died intestate or without a will. So of course, we'd want to get this a person like this a foundational estate plan, basically consisting of a will, living will, power of attorney, and those 3 documents that we always go into foundational estate planning. And then we advise that, look, you're stating you're separated. We can get that done. And we can basically say she doesn't get anything, and here are the reasons why. We're legally separated. She's had no involvement. Or the other advice I would have given them is, hey, just file for divorce. I mean, you guys haven't been together for 12 years. File for an uncontested divorce. I think both of you are good, and that would have resolved this entire issue as well. So there's 2 ways that could have prevented this spouse, the surviving spouse, from receiving money from this person's estate, and they were both pretty inexpensive. But now what happens is you're paying attorneys to go fight a battle in court to argue why she shouldn't be entitled to it and why she should be entitled to it. So now you're cutting into funds, and it just becomes a big mess. So what did we learn? Separation can only break a marriage in 3 ways: annulment, divorce, and death. If you're separated, you're surviving, and you pass without a will, your surviving spouse will still get your estate. And we could draft an estate plan, or quite simply file for divorce and then create the estate plan. As always, guys, if you want to talk estate planning with me, my name's David Campanile. I'm the owner of Campanile Law, located in the great state of New Jersey, and you can contact me at njestateattorney.com.